Welcome to This Explainer. If you're prepping for an exam on the clash between international and municipal law, well, you're in exactly the right place. We're going to systematically break this down and give you precisely what you need to ace those papers. We've got the foundational theories, the constitutional frameworks, and absolutely crucial, high-yield case laws that examiners are always looking for. So let's just jump right in. Okay, here's your roadmap for This Explainer, structured exactly like a top-tier exam essay. We'll cover 1. The two legal worlds, 2. Foundational theories, 3. The comparative matrix, 4. India's constitutional framework, and 5. Landmark case laws. Section 1. The two legal worlds. Let's look at the inherent friction right at the core of this topic.
If you're writing an essay, this question right here is your thesis. You want to ask the examiner, how does an international legal obligation actually become cognizable and enforceable inside a sovereign country's domestic courts? Basically, when they inevitably clash, who wins?
Now, here's an absolute pro tip for your exams. You should always use this visual metaphor in your answers. Municipal law operates on a vertical plane. It's totally hierarchical. The state sits at the very top, wielding supreme coercive power over the individuals down at the bottom. International law, on the other hand, operates on a horizontal plane. It's all about coordinating reciprocal interactions between sovereign, independent states who are, at least technically, equals. There's no giant global super-legislature dictating rules from above. So let's establish our baseline definitions. And hey, if you want top marks, you've got to cite jurists. Using J.G. Stark's modernized definition is perfect here. He defines international law as the body of law composed of principles and rules of conduct which states feel themselves bound to observe in their relations with each other. It's really all about common consent and state relations. On the flip side, municipal law covers the internal, domestic frameworks that actually bind the individuals living within a specific jurisdiction. We're talking about the Constitution, statutory enactments by the legislature, administrative rules, and judicial precedents. It's quite literally the law of the land. Moving on to Section 2, 4 foundational legal theories. Let's see how all this builds into the core jurisprudence. Okay, this is a classic exam comparison, so definitely take notes here. First up is the monistic theory, championed by Hans Kelsen. Monists argue that all law, whether domestic or international, is just part of a single, unified legal order. It all derives from a basic norm, or what they call a Grundnorm. From this perspective, international law is supreme and just applies automatically at the domestic level. But then we have the dualistic theory, pushed by thinkers like Tripel and Ancelotti. Dualists argue that these are completely separate, totally distinct systems operating on different planes entirely. They have different sources, like state will versus collective consent, and different subjects, meaning individuals versus states. So for dualists, international law needs to be explicitly adopted before it can apply domestically.
Building directly on that dualistic view, we've got two procedural theories. The transformation theory demands that for international rules to affect domestic subjects, they have to undergo a formal transformation. That basically means the state must enact a domestic statute translating the treaty into national law. Alternatively, you have the delegation theory. This one argues there's no real transformation happening. Instead, international law simply delegates the power to each state's own constitution to figure out how and when treaties get implemented.
Section 3, the comparative matrix. This is exactly what you should recreate on your test paper to really show off a structured understanding. I highly recommend taking careful mental notes here. Distinguishing these specific elements is practically guaranteed to secure you top marks. Look at the primary subjects, states versus individuals. Look at the source of authority, collective will versus supreme sovereign legislative power. And crucially, pay attention to the enforcement machinery. International law lacks a centralized standing police force. It has to rely on things like sanctions or diplomatic pressure. But municipal law? That's fully backed by the coercive, organized machinery of the state, like domestic police and prisons. Highlighting these structural differences really demonstrates deep conceptual mastery to your examiner. All right, Section 4, India's constitutional framework. Let's move from the abstract theory into practical application and see how a specific jurisdiction handles this conflict. Make sure to write down this exact phrase for your answers. India follows a harmonious dualistic approach. So what does that actually mean in practice? It means international customary law is generally accepted as part of the law of the land, unless, of course, it directly clashes with an act of parliament. However, international treaties strictly require formal legislative implementation before they can become enforceable rights for everyday citizens. If you're citing Indian law to prove your point, These right here are your golden constitutional articles. You've got Article 51C, which is a directive principle guiding the state to foster respect for international law. But the real teeth? That's in Article 253, which grants exclusive plenary power to the Indian Parliament to make laws implementing any treaty. Plus, Articles 73 and 246 link the executive power of the Union directly to matters where Parliament can make laws, like foreign affairs. Throwing these specific articles into your essay proves you completely understand the domestic machinery at work.
Section 5. Landmark case laws. Because theory is absolutely nothing without application. Examiners want to see how these theories actually play out in real, messy courtrooms. First up, we have the Gramophone Company of India case. It's honestly an amazing story. So a massive consignment of pirated audiocassettes was being shipped from Taiwan to Nepal, and it was transiting straight through the port of Calcutta in India. The appellant tried to use the Domestic Indian Copyright Act to seize the pirated goods, but the respondent fired back, arguing that under international conventions, landlocked states like Nepal have an absolute right to uninterrupted transit, meaning domestic copyright laws couldn't block the passage. It's a perfect clash of the two legal worlds.
And here is the crucial point and your ultimate legal takeaway. The Supreme Court laid down the rule that while national courts will deeply respect international law, in the event of an irreconcilable, direct conflict, municipal law will strictly prevail over international law. This case is the ultimate anchor for the dualist doctrine. It definitively verifies that domestic legislative text overrides international obligations within municipal territory. Our second landmark is the highly historic Vishaka case. The facts here are tragic, but the result was legally transformative. A social worker in Rajasthan was brutally gang-raped as retaliation for her efforts to stop a child marriage. When activists sought justice, they hit a massive wall. There was a total statutory vacuum in Indian municipal law regarding the prevention of sexual harassment at workplaces. It just wasn't there. So the petitioners urged the Supreme Court to look outward to the International Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, which India had ratified. The big issue: could the judiciary just enforce an international convention when domestic legislation didn't exist? And this brilliantly illustrates the doctrine of judicial incorporation. The Supreme Court ruled that because there was a complete gap in the law, and the treaty was consistent with fundamental constitutional rights, they could pull CEDAW directly into domestic law to formulate the historic Vishaka guidelines. You absolutely must cite this concept in your exams when discussing how international law operates during a legislative vacuum. It's a real game changer. Finally, we have the Jolly George Varghese case. In this one, debtors genuinely lacked the money to pay a civil decree and were facing imprisonment under Section 51 of the Domestic Civil Procedure Code. They argued that jailing them just for being poor violated the International Covenant on Civil and Political Rights, which India had ratified. The bank countered by saying, hey, Section 51 is validly enacted domestic law and has to be executed regardless of unenacted international covenants. So, how did the court resolve this? The Supreme Court proved that while mere executive ratification of a treaty doesn't automatically alter the internal law of the land, which upholds that dualist wall, they could use the principle of harmonious construction. They basically read down the domestic code to align with the treaty, holding that a debtor cannot be jailed unless there is proof of willful evasion or bad faith. It's a perfect example of balancing domestic sovereignty with international human rights commitments. As we wrap up this explainer, let's leave you with a concluding thought. You want your exam essay to tie together beautifully, right? You need to show that you don't just know the rules, but you actually understand the modern reality of how these two systems interact today. This summary perfectly encapsulates that modern legal reality. The strict barrier between the systems is continuously evolving. International obligations often act as an essential interpretive tool to help develop domestic justice when local laws are silent. So, as our world becomes increasingly interconnected, will the line between municipal and international law eventually vanish altogether? It's definitely something to ponder as you prepare for your exams. Good luck out there.